Pizza, we have plenty of pizza. So welcome everyone. What? The volume's good for me, is it good for you? Okay. All right. My name is Ellen Yarashevsky. I'm a professor here, and I'm also the director of the Monroe Friedman Institute for the Study of Legal Ethics, and along with a number of our terrific student organizations here, we are sponsoring today's event. And I'm going to soon introduce today's panelists. But before I do, I want to tell you that the Friedman Institute, which is actually just a year old, I've only been here for a year, was named after Monroe Friedman, a beloved professor who was here for many years. And we are developing a social justice program, and so we want to let you know about that. Our next event is Wednesday, October 18th, called Immigration Enforcement in the Age of Trump. And we invite you all to come to that as well. There will be flyers. Before I begin, I want to give my profound thanks both to the student organizations that are the co-sponsors of this event, as well as the Monroe Friedman Student Fellows. We have 3 fellows who are instrumental in organizing this program. Michael Gutentag, Michael, why don't you stand? Seema Rambaran, where is she? And Samantha Holloway. So thank you all. As you see, this program is being recorded, so afterward, if there are people who you talk to who want to listen to this, it will be on the institutional repository. Okay, so here we are, Charlottesville. When you think of Charlottesville, there's that iconic image of very hateful-looking people marching down the street with Nazi paraphernalia, with weapons, shouting things like "Jews will not replace us," "blood and soil," a term from Hitler's time, using the N-word. And you know that the ACLU, the American Civil Liberties Union, filed a lawsuit so that they could march in the park that they wanted to march in. They had been given another park, but they wanted a different park, and the ACLU filed a lawsuit saying that they had a First Amendment right to march in the park, and they won that suit. And that's a controversial issue unto itself. But as we look at Charlottesville, it's not just Charlottesville, it's the iconic image of looking at what's going on in the world today, whether it be in the United States, or around the world, whether it be in Europe, where there's an increase in racism, and expressions of racism, of Islamophobia, of anti-Semitism, of anti-gay, etc., etc. And so what we're asking today is we're going to look at the First Amendment in this country, which is a very robust, we have robust protection in this country for speech, right? We have said over time, we're going to talk about that fundamental to the notion of having a free and democratic institution is that people be permitted to speak, whether we hate their speech or not, that be permitted, and that the way we make progress in this country is through what we call the marketplace of ideas, right? Other countries do not accept this very notion, and you'll hear that today. Other countries actually punish various forms of what we're going to call hate speech. And so we're going to explore that, and we're going to explore ideas of, given the current climate, what do people think? What do our panelists think? What do you all think are appropriate lines to draw? Which is to say, should the lines in the law be drawn a bit differently? Now, but there are many people here who are not law students, and we thank you so much for coming. But we're going to talk about what the law permits and does not permit. Hate speech issues, however we define hate speech, and we'll talk about that. However we define that, there's hate speech on campuses, right? That's not First Amendment protected. That's not about the First Amendment. There's hate speech on Facebook. That's also not fundamentally about the First Amendment. What do I mean by that? The First Amendment is about government action. The First Amendment says Congress shall pass no law abridging the freedom of speech and other freedoms. So when we talk about the law and First Amendment, what we're talking about is what the government is permitted to do and not permitted to do. Facebook, social media, those are separate issues. That's about private action, private enterprise. Campuses, yet another issue, and I'm sure that our speakers are going to talk about that today. But we need to be clear as we talk about the First Amendment, what it is we are talking about. Fundamentally, the First Amendment says speech is protected, right? The government cannot outlaw, cannot abridge speech, except then we get to what the excepts are. And the excepts are fighting words that incite violence. So certainly conduct that is violent is not protected, right? And we're going to look at the lines of what do we mean by fighting words, what do we mean by incitement to violence. Part of the question that gets raised in today's climate when we have a case called Citizens United, which is the case that says basically money is speech, right? That in fact people can pour as much money as they wish into campaigns as protected speech, that if in fact people have that much money to promote speech, does that change the way in which we look at the First Amendment? That's one issue. Another big issue, of course, is when we look at race in America, when we look at what's going on, should we have a different calculation as to what's protected? For some people, using the N-word is just speech. For other people, it is so offensive and so horrible that it is an incitement to violence. So what do we do about that kind of an issue? So with that in mind, we have three terrific speakers today. I'm delighted. What we're going to do is each person's going to speak for about 12 to 15 minutes. We're then going to have a discussion among us, and then we're going to open this up to quick questions, okay? And so the first speaker is Dr. Jonathan Lightfoot. I'm delighted that he's agreed to come join us. He's an associate professor of teaching, learning, and technology at the university. And in January of this year, he was named as the director and launched the Center for Race, Culture, and Social Justice here at Hofstra. By way of background, I encourage you to look at the website for each of these people. I'm not going to read their entire bios because we like to get to the program. But Dr. Lightfoot received his PhD from the University of Illinois. He got his master's in education from Harvard, et cetera, et cetera. He has terrific credentials like everyone on the panel. He teaches a range of courses. He teaches children of color, the social construction of race in American schools, and he talks generally from an education perspective, which is what we're going to hear him talk about today. He writes, he contributes to an encyclopedia on education as well. So it'll be very interesting to hear that perspective. After Dr. Lightfoot, Professor Barbara Stark, who's a professor here at Hofstra. She's a professor and a Hofstra Research Fellow. She specializes in a range of different areas, from family law to international law, and she's here to talk with us about the international law perspective, and to some extent the comparative law perspective on issues of the First Amendment. She also is very well published, and she gives speeches at various conferences around the world, actually. And finally, our third speaker, well known to many of you, is Professor Eric Friedman. He's the Siggy Willits Distinguished Professor of Constitutional Law here at Hofstra. He has a range of specialties, from the death penalty. He's known nationally for his death penalty work, his work in criminal justice, but also for his work in the First Amendment and generically in constitutional law. He's testified before Congress. He's a sought-after speaker, and he's also published quite widely. So I'd like to welcome each of our speakers, and we're going to start. I'm actually going to try to keep time, if I can do such a thing, and give people little notes when they have 2 minutes left to go. So welcome, everybody. Dr. Lightfoot?
Good afternoon, Hofstra Law and guests. I proudly wear two hats here at the university. And one is as faculty of the School of Education, as mentioned, which has become part of the College of Arts and Sciences as of last year, actually, and also as the founding director of the Center for Race, Culture, and Social Justice. So let me begin by thanking Ellen for inviting me to participate on the esteemed panel of legal scholars, Professors Eric Friedman and Barbara Stark. I consider it an honor. I believe law professors and education professors have a lot in common. We both have chosen careers devoted to preparing young people to make great and important contributions to society. You train lawyers to fight injustice, and I train educators to fight ignorance. I often remind my students that ignorance of the law is not a defense. We have all heard the famous line, those who can do and those who can't teach. Well, I think we should reject such an idiom because we both find teaching a noble profession and a great confluence of art and science. We do not teach because we can't do. We teach because we believe it to be a noble calling of the highest order, despite the potentially lucrative lure of private industry and private practice. I believe every good sermon or speech should make at least 3 good points. So I'll quickly identify the 3 points I want to make in my brief opening remarks. First, historically, schools have been at the forefront of social progress and change. Amidst much criticism and little fanfare, we do our best to fulfill the mandate put forth by our founding father of education, Thomas Jefferson, who famously proclaimed, "The success of a democracy depends on an educated citizenry. A democracy that fails to educate its citizens is doomed to fail." The second point, the United States is a grand experiment, the product of Western European expansion to Africa to capture, disperse, and enslave human beings for profit under a new system of chattel slavery, which is the worst form of human enslavement, because it seeks to strip the person of his or her humanity and reduce them to the level of capital equipment. Until America acknowledges this original unholy alliance between capitalism and racism, it will continue to run on the treadmill of progress, running fast and going nowhere. In 1998, the American Anthropological Association officially stated that race is a social construct invented by European colonists during the 18th century to create hierarchy among people based on phenotype. Unfortunately, we have built a society based on the myth of race. It is scientifically baseless, incoherent, and illogical construct that continues to sow discord and division among the one and only human race. We are all cousins with a common African ancestor. However, whereas race is myth, racism is real. The sooner we address the fundamental truth in our schools and society, the closer we will get to speaking more love and less hate to one another. In 1903, W.B. Du Bois prophesied that the problem of the 20th century would be the problem of the color line, racism. He should know that the problem has continued well into the 21st century with no solution in sight. And finally, the third point, hate speech operates from the ism playbook. The messaging, the intimidation, the fear, and anger are all ideologically bound to notions of white supremacy, nationalism, patriarchy, and privilege. Malcolm X reminded us that capitalism depends on racism. One requires the other. And in fact, capitalism creates and is sustained by racism and many other isms, such as classism, sexism, ableism, and any number of the other structural and systemic power relationships characterized by institutionally sanctioned superior and inferior human connections. Our so-called president response to Charlottesville is yet another example of his typical narcissistic, egomaniacal, racist, entitled, and cavalier response to national crises. Lovers of freedom and democracy should be outraged at his attempt to place white supremacists and neo-Nazi fascists on the same moral and ethical plane as those who came to publicly defend liberty and justice for all. Americans, regardless of skin color, religion, gender, or sexual orientation, his combative, vulgar, and abusive speech, lack of empathy, and vindictive behavior are all indicative of a serious mental disorder. He is mentally unfit for presidential leadership, and we are all at increased risk for destruction. His tweets and public discourse normalize hate speech and behavior, and in effect tells the KKK it is all right for them to take off their hoods, come out of the closet, and speak their truth to white power in the public square. I have less blame for him than I do for the gerrymandered electoral college system, a relic from American slavery that allowed him to assume the presidency despite having lost the popular vote. unless the people who voted for this sick man think they should not be too held accountable for the trouble we are now in, or think that I have let you off the hook by blaming our electoral system for our current precarious state. Not a chance. Shame on you. The jury is still out on whether we should judge someone morally for their political stance. My specific area of educational expertise is social and cultural foundations of education. We credit education scholars such as John Dewey, George Counts, and Harold Rugg for articulating our conceptual framework. They did much of their work while at Columbia University Teachers College during the 1920s and 1930s, up to and throughout the Great Depression. They promoted the idea that schools should be critically connected to society and not be a rubber stamp for the growing corporate interests. Counts proposed that teachers dare build a new social order. He explained that only through schooling could students be educated for a life in a world transformed by massive changes in science, industry, and technology. He insisted that responsible educators cannot evade the responsibility of participating actively in the task of reconstituting the democratic tradition and of thus working positively toward a new society. The progressive educational agenda is being carried on by more contemporary scholars, such as Henry Giroux, who argued in Teachers and Intellectuals for teachers to reclaim their dignity while promoting an education that is more humane, just, equitable, and sustainable. Education for social transformation is built upon a critique of the technicist functional approach. It challenges indoctrination, masquerading as education, and demands a true education that enlightens and empowers. Paulo Freire and Donaldo Macedo define literacy as reading the word and the world, which reveals how the dominant culture works and uses this understanding as a roadmap towards change and freedom from oppression. I encourage my students to develop their critical literary skills and build a solid foundation for their professional educational practice by learning to read the world from historical, philosophical, sociological, and political perspectives. Our study of history should help us establish our orientation and point us in the right direction. Becoming lovers of wisdom, otherwise known as philosophers, helps to guide our thinking and hopefully our behavior. Our educational system is designed to produce more analytic thinkers and not enough prophetic thinkers. We're good at using logical analysis to determine the appearance and reality of our problems, but fail miserably when tasked with finding solutions to problems that require the prophetic application of ethics, morals, discernment, and hope. In short, analytic thinking can tell us what is or what appears to be, but prophetic thinking can tell us what should be and what is possible. Unending wars appear to be our reality, but peace should be what is possible. Our sociologists can help us understand what motivates human behavior in social settings, such as the growing use of hate speech, bullying, and violence in virtual and physical spaces. One of the many rude awakenings I learned as an adult was that hate speech, bullying, and violence did not stop when I graduated school and entered the real world with other adults. And finally, we look at education as a political arena. Many career politicians got their start as teachers. President Lyndon Baines Johnson was one. And others sought their first elected positions as school board members. We understand the politics of education along a spectrum from the right to the left and somewhere in the middle. To the right of the political spectrum is the conservative position, and it's characterized by individualism, survival of the fittest, competition, limited government, meritocracy, and above all, that so-called free market capitalism is the best form of economic organization for our democratic society. Somewhere in the middle and to the left of the conservative position is the liberals' position. They too are characterized by much of the same principles and values as our conservatives. They tend to be more open to bigger government, more collaboration, and a weakness for the oppressed up to a point. Again, fundamental to the liberal position, too, is the belief that so-called market capitalism is the best form of economic organization for our society, with a caveat of more regulation and oversight. Yes, the market can be brutal and unforgiving, thus the need for careful monitoring. To the far left of the political spectrum is where the radicals hang out. They tend to disagree with the fundamental politics of both conservatives and liberals, and they do not believe that the so-called free market capitalism is the best form of economic organization for our society. They agree that American-style capitalism has been wildly profitable, but they take issue with the scandalous and growing rift between the rich and the poor. It is shameful that the richest, most powerful country in the world has as much hunger, homelessness, poverty, and mass incarceration and violence and other social ills to the degree that it has. Apparently, freedom ain't free. We boast the most freedoms, yet we lead the world in mass incarceration. It is a bitter irony that 5% of the world's population has 25% of the world's prison population. Radicals argue for democratic socialism as a remedy for much of the social ills that plague American society. They ultimately blame the so-called free market capitalism for social inequality manifest by racism, classism, and sexism. I think the best example of the connection between educators and lawyers is the 1954 Brown decision, where Chief Justice Earl Warren declared that separation was inherently unequal, which nullified 58 years of Jim Crow segregation initiated by the 1896 Plessy v. Ferguson decision. The Brown case, along with the 1955 lynching murder of Emmett Till and the 1956 Montgomery, Alabama boycott, stirred the nation's conscience and will for change. Schools were the catalyst for economic, cultural, legal, and social change. The modern American civil rights movement, under the leadership of Dr. Martin Luther King, sought to force America to own up to its hypocrisy, racism, and militarism. So, we look at what the Founding Fathers did, how they looked at speech. They decided that the First Amendment was where they were going to include the freedom of speech. They looked to the Bible for guidance, the Judeo-Christian Bible, and scriptures guided them. Yehuda Berg says that words are singularly the most popular force available to humanity. We can choose to use this force constructively with words of encouragement or destructively with words of despair. These two scriptures that I think the Founding Fathers relied on were the first, John 1:1, which says, "In the beginning was the Word, and the Word was with God, and the Word was God." If words are of God and God is love, then our words should be lovely. And if God is good, then our words should be good. The second scripture, Proverbs 18:21, says that death and life is in the power of the tongue, and they that love it shall eat the fruit thereof. So my attempt at the exegesis of this text is that those who embrace speech that affirms, uplifts, and gives life, they use the power of their tongues to speak life to our sick and dying world. Alternatively, the fruits of those who now sow discord, sin, and hate is death. For truly the wages of sin is death and destruction, which hateful sinners reap unto themselves and those unfortunate to fall into their path. I don't have time to go into my second and third point in detail, but I hope when we ask questions and have dialogue, I'll be able to do so. But thank you up to this point.
Thank you. We will have an opportunity to talk about people who disagree with that perspective and what that means in terms of for First Amendment itself. But what we're going to do is talk now about, so what about the First Amendment law doctrine in light of in light of the remarks. So Professor Stark.
Good afternoon. I'm going to talk, my 3 points are basically the origins of the prohibitions against hate speech, the definitions, the legal definitions under international law and international human rights law of hate speech. Third point, the questions raised by hate speech for freedom of speech issues, including a sampling of some laws from everywhere. And if there's time, I'd like to conclude with the example of the Danish Cartoons as one of the most problematic examples of hate speech. Where is it in action? Okay, the origins of the prohibition against hate speech came after World War II in the founding the Universal Declaration of Human Rights. This was a coalition of people who recognized that the effective employment of propaganda by the Nazis had been all too effective. Representatives of the new countries from the Third World who had been victimized by ideologies of European racial supremacy, and communist governments that were opposed to granting free speech to fascist movements. The definitions, the legal definitions of hate speech that were developed, the most important is found in the International Covenant on Civil and Political Rights, which is half of the International Bill of Rights. And it says, quote, any advocacy of national, racial, or religious hatred that constitutes incitement to discrimination, hostility, or violence shall be prohibited by law. Second definition is in the Convention on the Elimination of Racial Discrimination, and that's a little bigger. All dissemination of ideas based on racial superiority or hatred, incitement to racial discrimination, as well as all acts of violence or incitement to such acts against any race or group of persons of another color or ethnic origin, and also the provision of any encouragement to racist activities, including the financing, shall be prohibited by law. So that's a wordier version of it. Hate speech, as defined in these international instruments, raises 4 basic freedom of speech issues. First, in other words, how does this show up? How does this appear? First, the Prohibition against hate speech prohibits racial, ethnic, religious epithets, including the N-word, the K-word, the W-word, and all these other words, half of which I don't know who they refer to, and I'm afraid to Google them, because then I'll be on lists forever to find out. They're only permitted as ironic self-reference by members of the groups. These epithets are prohibited under general interpretations of hate speech because insofar as they're intended to harm, offend, or marginalize the members of the groups. 2, prohibition against demonstrably false factual propositions. And the most common example is Holocaust denial. And I'll tell you a little bit about how that plays out. 3, prohibitions against hate speech take the form of laws prohibiting advocacy or incitement to racial or religious intolerance, hatred, or violence, including calls for exclusion or suggesting that particular groups, quote, go back to where they came from. 4, and finally, when epithets or pictures, especially in the context of gender discrimination, pictures, create a hostile, marginalizing, or excluding environment, they can also be prohibited. And I rely here in this taxonomy on Frederick Schauer, who wrote an article on the exceptional First Amendment. These are the 4 places it mostly shows up. How are these various examples of hate speech actually prohibited? What kinds of laws? Examples: Germany and Israel bar Nazis. Germany, Israel, and France ban Nazi items, including swastikas, Nazi flags, sometimes Mein Kampf. Canada, Germany, and France allow sanctions against Holocaust deniers. The Netherlands outlaws public insults based on religion, or sexual preference. All Scandinavian countries, as well as South Africa, New Zealand, Australia, Canada, and the UK, follow the International Covenant on Civil and Political Rights that I cited at the beginning by making it a crime to engage in the incitement to racial, religious, ethnic hatred, or hostility. In international law, as Schauer concludes, in the rest of the world, freedom of expression is understood as an important value, to be considered along with other important values of fairness, equality, dignity, health, privacy, safety, and respect. In the United States, freedom of expression trumps. It prevails over even the most profound of other values and importance, and it prevails over the importance of other issues. The Danish Cartoons were published in 2005. These appeared in a Danish newspaper, and as some of you may recall, they mocked Muslims. They included caricatures of the Prophet Muhammad, including one in which Muhammad wears a turban in the shape of a bomb. These cartoons led to widespread protests and riots, the severing of diplomatic relations between an Arab state and Denmark, death threats against the cartoonists, and boycotts of Danish goods. The cartoons were republished by several European states, including France, Germany, Italy, and the Netherlands. They were not published by most major newspapers in the US, the UK, and Canada. Whether it made any difference is a question, is an open question, because they were readily available on the internet. Protests reflected the understanding of many Muslims that Islam bans any image, let alone cartoons, of the Prophet. As Professor Rudy Title noted at the time, quote, "Cartoons published against a backdrop of political and legislative acts perceived by many Muslims as disparaging to Islam by newspapers that wouldn't consider publishing anti-Christian or anti-Jewish cartoons." The international responses included 57 Islamic states, organized the Organization of Islamic Conference. They got a General Assembly resolution of 100 states, 50 abstentions, deploring the cartoons. The UN Council on Human Rights eventually, in 2011, issued a lengthy statement deploring the cartoons and encouraging, I have the exact language in books that I brought, encouraging states to cooperate, to educate their populations against intolerance, and to generally steer their countries and their inhabitants away from this kind of incitement to discrimination.
Thank you for those opening remarks. We're going to be able to explore questions, Professor Stark, such as, do you think the United States should move closer to the adoption of those kinds of laws, particularly given what Professor Lightfoot has said for? We're going to ask you the same question, but now we're going to turn to the American exceptionalism I suppose we could say that, the view, United States, which does promote the First Amendment above all. So Professor Friedman, your opening remarks.
Because the idea of the importance of free speech as a key element in promoting the search for truth takes, not surprisingly, a large battering at events like this. What can be true about claiming the inferiority of whatever group it is that you might have in mind. I want to focus on that element in my remarks, leaving aside some important other thoughts which are in the handout that's been distributed about the importance of freedom of speech as promoting the individual autonomy of each human being. Now that a number of undergraduates have left, is anybody still in the room who knows who John Stuart Mill is?
I wrote a paper on it.
Ah, good. You wrote a paper?
Fast.
Okay. Then I think John Stuart Mill was right when he said something that Abraham Lincoln always remembered, both in his very successful law practice and in his political career, which is, he who knows only his own case knows but little of that. And that's equally true whether your own case is the case against slavery, which was savagely suppressed to the point where more white people than black people were lynched in the South before the Civil War. Or whether your case has to do with Holocaust denial. First of all, believe it or not, there is always a chance that the other guy is right, no matter how passionately you believe in whatever you believe in. Lots of perfectly obvious truths, like the fact that witches exist, were overcome in time. And one reason we no longer burn witches is that we stopped burning people who deny the existence of witches. More likely, though, whatever the truth is lies somewhere between what the contending sides say. Take the Holocaust denial example. There was a spectacular trial on this in England some time back, involving an outrageous nut who said that no Jews died at Auschwitz because the ovens weren't suitable for the purpose of extermination. Well, that outrageous statement provoked an Israeli researcher to go disprove it. And lo and behold, he found that the received number for deaths in Auschwitz was wrong and should be revised. And his calculations have since been accepted. So the truth benefited in a way that it would not have benefited if the original statement had been successfully silenced. And if you tell me that that's all very nice, but it's just too risky to permit the original statement because it's only a short step from denying the existence of the Holocaust to let's kill all the Jews, I tell you that that sort of reasoning under the name of natural tendency test is one of the greatest legal tools for the protection of incumbent power structures. It began in England, where they suppressed speech whose natural tendency would be to sow disaffection between the king and his subjects. Statements like, the king draws his legitimate power from the consent of the government, and migrated to America, where it was responsible for the waves of domestic repression that led to the formation of the ACLU. Take, for example, Schneck versus United States, a 1919 Supreme Court case in which Schneck and his co-defendants called for repeal of the draft law in a pamphlet which said this is despotic legislation, and the people who are supporting it are cunning politicians and a mercenary capitalist press. The defendants were convicted of obstructing the draft because, quote, words of the Supreme Court, the document would not have been sent unless it had been intended to have some effect, and we do not see what effect it could be expected to have upon persons subject to the draft, except to influence them to obstruct its carrying out. So the original statement sends the people to jail for decades because the natural tendency of that statement would be to lead to draft resistance. And by this means, a woman named Rose Pastor Stokes was convicted for saying, quote, I am for the people and the government is for the profiteers. A statement she made in a talk to the Women's Dining Club of Kansas City. There not only were no soldiers in the audience, there were no men in the audience, but the government prosecuted her and successfully argued, quote, our armies can succeed only so far as they are supported and maintained by the folks at home, and this statement of hers would tend to chill the enthusiasm of mothers, sisters, and sweethearts for the war. Off to jail she goes for 10 years. So that is the background against which the Supreme Court in Brandenburg versus Ohio in 1969, during the Vietnam War, gave us the current First Amendment rule, which it has strictly enforced ever since, that you can only punish speech on the basis that it will lead to lawbreaking if it is direct incitement to imminent, unlawful violence delivered under circumstances where such violence is likely to occur. And that has been nothing but good for minorities. It protected Vietnam protesters who were arrested for language that the authority claimed threatened violence. Hess case, Watts case, where the speaker said, if they send me to Vietnam and give me a rifle, the first person I'm going to get in my sights is LBJ. Conviction reversed by the U.S. Supreme Court. It protected the NAACP from a massive judgment that local businesses in Mississippi had obtained against the NAACP for protesting race discrimination by conducting a boycott, during which there were a number of acts of violence against blacks who were not conforming to the boycott. But judgment overturned by Supreme Court because those acts did not occur as the result of direct incitement to imminent unlawful violence. And the same rule would protect a protester, an anguished father in Ferguson, from saying in front of a police station, this den of injustice deserves to be burned down. But even so, in our particular context of hate speech, there is no question that the Brandenburg Standard certainly has its risks. It not only means that essentially all of the laws Professor Stark has listed for you would not be valid here. But more basically, it means that people using inflammatory language can advocate for Nazi views, even though we all know that if the Nazis ever came to power, the first casualty would be freedom of dissenting speech, and thereafter we would see mass slaughter carried out by the government. And no one discounts that risk. But the American view is that we are consciously taking that risk because it is outweighed by others that experience equally supports. And two in particular. First, we are not comparing the world we have now to a world in which the only speech that exists is the speech that I like. We are comparing the world that we have now to a world in which the government gets to enforce limits on free speech. In other words, the power to define and enforce the prohibitions is in the hands of the incumbents. And so if a newspaper is to be stopped from publishing some particular cartoon, the government is going to have to do it. And so American law is premised on the idea that when it comes to free expression, the burden is not on the speaker to justify how valuable speech is, but on the person who wants to control the speech to explain how he or she plans to limit the enforcement system. Second risk. To silence fringe groups is to build support for them. First of all, they can legitimately complain that having been excluded from the system, they have no recourse but to turn to violence. Or in a lesser form of this, having been excluded, persecuted, they can appeal to voters on the basis of their martyrdom as opposed to their ideas, and we've seen a good deal of that in populist movements around the world. Second, they attract support way beyond their numbers or their merits from people who do not agree with their message, but do agree with their right to convey it. And by far the best thing that ever happened to the Nazis who planned to march in Skokie, Illinois, was that the government tried to prevent the march, whereas the Communist Party was left free to go off and seek votes and didn't get any. In contrast to what happened after the Second World War in countries that did try to suppress the Communist Party, and it responded with underground campaigns, sometimes successful, to overthrow those governments. By far the worst thing that ever happened to the Nazis in Skokie was that they were allowed to march. As a result of the community counter-response led by a Holocaust survivor named Barbara Steiner, and the donations that poured in from people saying, never again, there is now a museum on that site, and it shows, it has in it, it's the fourth largest Holocaust museum in the country. It shows cattle cars, it shows artifacts from the Holocaust, and local videos of people, survivors of the Holocaust, and a series of exhibits about genocide around the world, with the result that Barbara Steiner, the Holocaust survivor who started it all, is quoted in the Wall Street Journal as saying, the best thing that ever happened was the Nazis came to town, because we get 250,000 visitors a year, many of them from the inner city of Chicago who don't know anything about Germany or anything else, right? But whom we are educating for the benefit of the next generation. So yes, American free speech law is an outlier, and yes, it has much to criticize, but it comes from a lot of hard-won experience around the world, and I would urge those who want to rewrite it to be careful for what they wish for. Now, having said all of that, I will conclude in 2 minutes with 3 points. Negative constraints on government are good, but the only thing required for evil people to triumph is for good people to remain silent. And lawyers and educators do agree that the word is the most powerful weapon in human affairs. You all have freedom of speech, and so do your adversaries, and who wins is in your hands.
Okay, so we're going to have a discussion. Well, I want to push back on, we all have freedom of speech and who wins is in our hands. So we accept in the United States, right, the First Amendment is the equivalent of our iconic right. But many people don't have that right. Many people don't have it. And one of my colleagues at a recent event said, the whole point of law in this country is supposedly to increase participation and the ability of every citizen to participate. And if in fact what has happened, as Professor Lightfoot points out over the course of years, that we live in a society that's founded upon racist and other negative ideologies, why is it that we should continue in this vein, which is to say, Professor Friedman, I want to push back a little and say, in light of Citizens United, in light of what's now going on in terms of the racist and vitriol that's being presented, in light of what's happened in other countries, is it time for us to revisit the incitement question? Because my view of incitement may be different than yours, right? Professor Stark really wants to say something first.
What I was going to say was, and I know Professor
Are
Stark
those microphones working?
We'll support you on this. H.L. Mencken has said, yes, freedom. The press is free to those people who own presses. And much more recently, that view that freedom of speech is all very nice for the rich people who control the increasingly monopolized channels of communication, was not only the subject of law review writing, including a full issue of the Hofstra Law Review at a conference which we had here, and I was one of the directors, but more critically, legislation providing a right to reply so that the owners of the press didn't get total control of their pages, but if they attacked somebody, the statute provided you got to put in an answer, held unconstitutional by the Supreme Court for the very good reason of the last point that I mentioned, which is that, sure, that's great, but the increase in government power to mandate the message comes at the expense of the individual to control their message, and where there really is a monopoly, as in broadcast frequencies, we can and do that. It's constitutional. It's been held to be constitutional. But where all you're talking about is that the other guy has more money than you do, we are not going to upset that, not so much because we are committed to capitalism and that he who's got the most money has the most truth, but because we know that lots of truths that had neither money nor majority support, like anti-slavery, won over time, or votes for women as far as that goes, won over time because of the power of their message and the passion of their supporters. And again, given the risks of allowing the government imposition of orthodoxy, like slaves are happy, like the women should stay home and forget this political stuff, we are not going to go down that road, notwithstanding that the current situation at all of those times, and the present time, was totally unacceptable to people challenging the status quo.
So, Professor Stark, you're talking about all these various laws in Europe, right, in Scandinavia, that prohibit various forms of speech. Is the situation different there? I mean, we see demonstrations, we see lots going on in France and elsewhere. What's been the effect, if you want? As compared to the U.S., which is to say, if we went further, right, if we said the First Amendment is one right, but let's balance it against other values, the communitarian values that Professor Lightfoot talks about, and we would move a little further saying incitement, we're going to say walking down the street in Charlottesville with a gun is in itself, and spouting anti-racist, Islamophobic, anti-gay violence, that in itself is incitement and shouldn't be permitted.
I don't see what we lose by going there, but I'm much more interested in people out there.
We'll get to them.
Okay. It's, free speech certainly has been used and certainly has moved forward many important struggles. But the part of free speech that has enabled hate speech, that has enabled, hate speech is incitement to discrimination. And in RAV, for the court to say, as long as you just say, these people should go back where they came from, these people are inferior to these other people, that's fine, just brings us to a culture of intolerance and polarity that I'm very uncomfortable with.
So should we outlaw it? I mean, that's the next question. At what point do we outlaw? Professor Lightfoot, what do you say? Outlaw, and the question is, what are we outlawing? Because we can't all agree on what hate speech is, right?
There are parameters. We can't agree. It's the same thing, we can't all agree on what protected speech is, but the courts struggle through it and apply it in specific situations, and they would do the same thing by saying there's a prohibition against hate speech, against speech whose purpose is just to denigrate one group of human beings.
Okay, so answering the question, should racist speech, are you saying racist speech or hate speech be outlawed? Is there
Some version. There's a continuum, and the question is, we want to push back against the current continuum, which Professor Friedman told us.
I think the short answer is no, but it's more nuanced than that. We need to, more complex, and we need to, I think, take these cases on a case-by-case basis. But if I were to say no, that they should not be legally or outlawed in the sense that, the court of law, that, you are held accountable and you face consequences for such speech. But I would certainly advocate to be held civilly responsible. So you can, and I would think the threshold of the evidence is certainly lower, tends to be in civil laws as opposed to criminal law. I would think that certainly we need to look at the institutions. I'm more concerned with how our institutions manifest as to promoting equality and justice and so forth. So those adages that sticks and stones may hurt my bones, but names will never hurt me. This is really not true. It's patently not true. It's cliche, but certainly if it, as my colleague Robert Stark says, that yes, if it intends to discrimination, if it does condemn one to second-class citizenship or marginalizes in a way that somehow prevents them from exercising their full rights as citizens of this country, that we need to explore how we can civilly prosecute and hold someone accountable for that kind of thing. But at the level of institution is where it concerns me, because that's where we tend to get the confirmation of one's inferior status. So your opportunities may be less. Your ability to have free mobility throughout the public sphere is limited. If at the institutional level, those people who choose to hate and to use the kinds of speech that leads to discriminatory behavior and violence and so forth, yes, they should be held civilly accountable. But through our governments, through our educational system and so forth, that's where we need to address it. We need to address it at the earlier ages. School is the most socializing institution that we have, and so we need to socialize our students early on of what it is to discriminate, what it is to bully and to incite violence and so forth. And I don't think we're doing that. And that's why we have the problems I believe we have.
Professor Stark, you're shaking your head. As he's speaking, certainly education, I mean, is key and important, but what do we do now? We're in a law school, we're now at the question of, so should certain kinds of speech be criminalized? Should people be held civilly liable? Or is Professor Friedman correct that what all that will do was embolden the people whose speech is denied?
No, many of these questions have been answered by many other courts and many other tribunals. Let me give you some of their responses. The point about civil accountability, that's why Brigitte Bardot, when she said send the Muslims back to Algeria, she was fined. She was fined for saying that. That's a deterrent. That's saying that kind of that's not discourse. That's not, we don't need that in the public sphere. That's just hate mongering. It took 5 years for the international community, such as it is, to come up with any kind of coherent response to the Danish cartoons, which were so troubling. And what they came up with was the UN Human Rights Council, adopted by consensus, a resolution encouraging exactly what you said, encouraging the creation of collaborative networks and human rights education, which is required in the International Bill of Rights. And again, the U.S. is an outlier. There's a whole curriculum for kindergarten through 12th through graduate school on human rights education that the U.S. knows nothing about, except here at Hofstra.
Except here at Hofstra. Well, that's good that we do that here at Hofstra. Okay, but given the fact that that's true, and we have a very different history in the U.S., what would it look like to actually either civilly or criminally punish people here when we haven't educated people in that vein for the last 200 and something years, or 100 years at least?
It would.
Or how do we do
The first thing it would do is make a criminal of Abraham Lincoln, who supported the idea of returning the blacks to Africa as a solution to the slavery problem.
Well, that's a long time
believing that integration would never work. But besides all that, you cannot enforce civilly a judgment that would violate the First Amendment, because that is state action, and those of my students who are here will find all about it in the second semester. But the case is called New York Times versus Sullivan, which by common agreement is the second most important Supreme Court case in support of the civil rights movement, second only to Brown versus Board of Education. And in New York Times versus Sullivan, Sheriff Sullivan, who had been abusing civil rights demonstrators in Montgomery, Alabama, lost a libel suit in the U.S. Supreme Court as against the defense of what he wants as a civil judgment for libel between two private parties. And no, if the state is going to take the money of the New York Times and give it to Sheriff Sullivan, that's state action. The state of Alabama cannot do that without abiding by First Amendment constraints, with the result that, and the most influential brief in that case was filed at the Washington Post as an amicus. And the amicus brief of the Washington Post was a remarkable thing in the world. That it just said, the following judgments are now found in the books of the various southern states. $500,000 against CBS for reporting this, $200,000 against NBC for reporting this, which is listed and respectfully submitted. Right? Those civil judgments thought to be immune from the First Amendment were in fact trying to silence the people that the incumbent power structures in those communities want to silence. So that is by no means to suggest any disagreement whatsoever with the concept that, of course, education is where we all want to be. It's education about gays, right? That has gotten you to the point within 50 years where gay marriage is a constitutional right, a prospect which I can assure you, if I had predicted to my father, he would have said, don't be ridiculous, considering that the conduct itself was criminalized in every state. So, of course, education, persuasion is exactly the tools that have been much neglected and do need to be much reinvigorated, which does not suggest that we should make any change to U.S. constitutional law in the meantime.
Okay, I'm going to open this up to comments and questions. Comments or questions? I still want to push back on this question of, we're in a different world right now. What we're seeing is really different in this era. And what do we do about that? What do we do about money buying speech? What do we do about the levels of racism? Where someone said to me, in a world of increasing fascism, are we going to defend the right of fascists to do what it is that they would like? So, who, someone had their hand up? Yes.
Sure, I have a question. Hi, oh, sorry. Not the best for that kind of stuff, but this is just, I just want to say it was a really good panel. I think everyone had really good points to make and everything else, but to get to my question is, I guess it's kind of my own point, is in the world of when we've seen the best ideas have flourished, or once the most unpopular ideas, going back to his idea about John Stuart Mill and the concepts he created, which is ironically some of the things I wrote about a couple of years ago, but if we look at it, you know, the idea that we can defeat bad ideas and fascism, I think the way to defeat that is with free expression and free thought. I think people talking to one another. So is it not? Is it possible? I want to ask. I guess this for Jonathan. Can you have more free expression as a way of deterring hatefulness, and by which I mean giving people the right to, not associate with these people, not let them in their businesses, not want to talk to them? Can we see that as a legitimate way instead of having, putting it on the government's shoulders and giving more restrictions to people who are going to abuse it and giving to it? And going back to the cartoon thing, is that I don't like what the cartoons were, but is there some, if you're going to put some blame on the cartoonists, are you going to put blame on the religious muftis and the clerics who are saying, oh, you have to go out and kill people because they built a drawing? And if you're going to put blame on the cartoonists, you have to put the blame on them too if you're going to be like that.
I must say I agree with both points, which is the absolutely legitimate criticism of President Trump and the resulting social climate in many places, right, is to legitimize and normalize viewpoints that, apart from anything else, were utterly socially out of bounds, in total contrast, again, to the kinds of conversations you might have heard 30 or 40 years ago in everyday speech, and the trajectory of the last 3 or 4 years has been a good trajectory, and it's fabulous. It's the reason, it's the reason why when I give a public talk, I now say he or she, which I might not have done some years ago. Terrific. Everyone's consciousness has been raised, and that, of course, that's what we should be. And then on the second point, yes, I do think it's kind of putting the shoe on the wrong foot if the newspaper editors are to blame for the violence that was incited against them, and American law is, again, very strong on this point, and the technical term is heckler's veto. If I say something that causes you to be so outraged, like women were never equal in the first place, that you come and attack me, we're going to arrest you, not me, because otherwise the unpopular view would be at the mercy of the mob. And so, yes, I think both points of the law would make.
Professor Starr?
2 points, and this is turning to the law, which is not usually always where I want to go. But one on the question between journalists versus hate mongers. The European Court of Human Rights addressed that exact question in 1994, where again, a Danish journalist, I don't know why they're so out there, but a Danish journalist has been interviewing young racist thugs. And he highlighted those points of the interview. He edited the interview so that the most offensive things that they were saying was exactly what was heard on TV. And what the court said was the young racist thugs were found guilty of violating hate speech regulations. The journalist, on the other hand, was not found guilty. But he was encouraged by some members of the court to be more emphatic, to be more clearer that what they had been saying was a violation of Danish and European law. But it is, the Washington Post journalists can get that out there, but they should get that out there and frame it in a responsible way. The other point is on the U.S. Supreme Court saying that they said in a later case following, so that was Sullivan, sorry, in a later case, they said, in RAV, they said that legislation had to treat racial epithets and epithets directed at racial bigots the same way. Okay? People saying marchers in, there, as our president put it, there was bad behavior on all sides in Charlottesville. And why? Why, even under our own constitutional jurisprudence, why does that have to follow after the 14th Amendment? The 14th Amendment's commitment to racial equality. Why can't we distinguish between those who are proudly racist and those who are protesting racist bigots?
The answer is because that would mean that if I say the 14th Amendment was the biggest mistake that ever made in American history and the economy never flourished as well as it did under slavery and the slaves were happy, that would be illegal.
No, parts of that would be illegal. Not all of it would be illegal. Parts of it would be questionable, and parts of it, we can break things down.
We pretend like we have a race neutral court, right? We pretend like the First Amendment is race neutral, right? I mean, so what she's saying is, if what we did is something akin to what they do in Europe, look at the First Amendment in light of the 14th, we'd say cross burnings are really different from other kinds of demonstrations, right? The cross burnings means something different because of our history of slavery and racism in this country.
You could certainly do that. Of course, people made the exact same argument about burning the American flag, and they got 4 votes on the U.S. Supreme Court, in which those 4 said, well, you can say all you want about socialism or a single tax, but burning the American flag, now that's serious, and some things have to be beyond question or beyond dispute. And by the way, there's a proud history of that kind of thing. There were a number of, in the period that I talked about of the earlier cases, there were a number of laws outlawing the waving of red flags as a symbol of opposition to, as a symbol in support of socialism, opposition to existing government. And more recently than that, the U.S. Supreme Court had to overturn a conviction for somebody who was convicted of taping a peace symbol onto an American flag as a protest against the Kent State shootings. So, I would love a world where you named all the Supreme Court justices, and I certainly encourage everybody to engage in political action such that the next set of Supreme Court justices will bring the Constitution more into line with what they desire. But I have to tell you that the whole purpose of the First Amendment is to prevent the majority from getting what it wants.
Or as some people have argued, the civil rights movement would not have existed if not for the First Amendment. So,
Yeah.
Question, there was you had.
Yeah, it's just because there was a question that, I mean, your name again, Professor? What's your name again?
My name?
Yes.
Professor Yarashevsky.
Yeah, so the professor asked if in a world where fascism is growing, we should allow fascists to express their beliefs and their ideas. And as the other colleague here just said, I think free expression is the best way to, I think the best way to expose someone's stupidity is to let them talk. So, I am not American, I am Brazilian, and I just arrived here 2 months ago, so I don't really know the historic background and everything. But what I have seen on the internet and stuff is that whenever there is going to be a fascist, let's say, talk or demonstration, you always have the anti-fascists. They try to don't let the fascists express themselves. So I think that if they let them express themselves, people will see how stupid they are, and then they would not believe on them, So, that's my opinion on that.
Comment? Professor Lightfoot, you haven't said something for a while.
I'm learning from my comments here and from the audience here. But, look at, as I made in my opening remarks, we can't underestimate what the connection between capitalism and racism implies. And I think to the extent that we want to reduce racist speech and racism writ large, that we may have to relook at our system of economic organization and how we connect it to our democracy. Because it, at its core, really sows discord and allows for social, economic, and cultural inequality. That's just at its core. And until we recognize that, it's almost as if we want to have our cake and eat it too. It's just, at this point, the way our system is structured institutionally, our laws are, as they evolve, and we come to a better understanding of, what's going on, and how it's changing, until we really look back and give it some historical context. I think again we're on a treadmill of progress. We're not going to go anywhere, and it actually requires some kind of revolutionary deconstruction of the way in which we operate. To me, it's kind of a no-brainer, but everybody doesn't see it my way.
But it sounds like you're saying so more speech is the right answer.
Possibly, more speech. Yeah, I like what you said, young man. We need to ferret it out. Yeah, come on out with it so we can know what we're dealing with here. Because if as Professor Friedman says, if we suppress certain speech and it emboldens them, it makes them want to come out more forcefully and to come up with more heinous ways to let people know that they're frustrated, they're dissatisfied, that they're angry, and so forth. It's difficult. Who knows what happened in Las Vegas? Why this guy, who, according to his brother, said, this came like an asteroid. We never saw it coming. Is he angry at what's going on here? Is he angry at a presidential administration, leadership, characterized as it is now? There's a lot of anger out there, and when it reaches this boiling point, and suddenly you have instances where mass violence occurs, something's not right. We're not doing something right. I don't know if we're doing something right in our schools, in our government, so forth. Economically, we've been denying opportunity to people, and so we've been discriminating against others. So we really, I think, have to look at what we do at the institutional level to, sow discord, among the populace.
Okay, so I like to believe that the U.S. Constitution was founded on the values of non-racism and non-sexism and non-all divides. So, but then what you find increasingly is some of the members of the public falling to uphold these values. So I would like to understand the role of the law, or how we can make the law more powerful to control such situations. So I would like to understand, is there no constitutional interpretation towards the enforcement of social rights, or if there is a restrictive interpretation on the standing rules? So I would like to understand.
The U.S. Constitution, in contrast to the Constitution of many countries around the world, is strictly a series of restraints on government, except as specific powers are granted to government to do things, and there's supposed to be kind of a strict enumeration. And so, in many countries, there is a right to housing, and a right to education, and a right to healthcare, and a right to, and many constitutions have things like that. But all constitutions that do then say, however, the implementation, enforcement of this right lies in the hands of the legislature, and it has a huge amount of discretion, and in most cases total discretion, in the degree to which it's actually going to provide those rights. So the U.S. Constitution is essentially a charter of negative liberties rather than positive liberties. When it comes to the Bill of Rights, they are rights to have the government not do oppressive stuff, rather than rights to have the government do positive things. Many of the power-granting parts of the Constitution, the things other than the Bill of Rights, are the place where the government has the power to do good things, but not the obligation. It's not an individual right. That comes about through political action and democratic majority building. The Bill of Rights and where the courts come in are things the government can't do, like suppress speech beyond certain.
But Professor Spark points out it's different under international law
Yes.
and other countries.
But one other thing, and this goes a little bit towards capitalism, and that is what the United States was not founded or based or predicated on equality and
Non-racism.
certainly not non-racism, but also what was the minority that Madison was so concerned about being oppressed by the majority. Madison was concerned, at least some scholars say, that the non-property majority would overcome the good white men of property, and those were the ones who had to be protected by making sure that majorities couldn't take over.
Oh, well, he listed a whole bunch, and my students know.
Okay, we're gonna move on to
A
the
religious
question.
sect may degenerate into a faction,
Right.
right? And of course, race, women, but poor people, debtors may take over, and
Right.
yes, every one of those things were
Risks.
risks, and we had to provide mechanisms for. No question about it, which is why the U.S. Constitution has been amended so many times over the years, in part to give the vote to women, to mandate racial equality, to give Congress the power to wipe out slavery, and a lot of things which it didn't have until political processes changed it.
But one other thing, and that's that nobody's saying no speech. Lots of speech. Of course, speech is the answer to so many questions. Just not speech blaming one group or one sect or any group of human beings for everything else.
Question.
Okay, so as Professor Friedman said earlier, there's always the chance that the other guy is right. So when you even speak about, well, not even speak about, but if you were to impose like these restrictions on the First Amendment, wouldn't that lead to like an inherent confirmation bias? Because you wouldn't really be able to more or less express yourself in opposition if you run these risks of restrictions.
You can, opposing what? You
Right,
can
no, I'm not
oppose
saying-
everything except saying, you can't say women are just
Well,
adults.
well, all I can tell you is that when Catherine McKinnon successfully lobbied for the passage of an ordinance in Indianapolis, which outlawed pornography on the grounds that it created negative images of women and portrayed them as people who like to be taken advantage of, and so on and so forth.
Right.
The ruling was, yes, it might actually do all of that, which would be counter to the truth, but there's a cure for that evil, which is lots of people tell them so, and in fact, my class, preview coming attractions, my class will get in the spring to find some feminist pornography that was written, you know, to show that we can be as non-objective as the other guys. And yes, of course, that's...
But that all means nothing if it's profitable. If the market says that they're demanding that women be objectified and that women, occupy a certain position in society because it's profitable and the market supports it, then the political will and so forth will,
But
That's
this
true
is
about the
getting
federal-
really
that's true about
abstract
the
and
Federalist
academic.
Papers. That's
Right,
true
this
about
is like the level of abstraction of confirmation bias. I want to bring it back to like Charlottesville and walking down the street with a gun on your phone, saying black people, whatever, but calling them the N-word and saying they're inferior and Jews should be shot or whatever. I mean, that's a little different than confirmation bias, is it not? I just want to throw that in there before we...
Well, racism can be profitable too.
I mean, and look, I don't support open carry laws anywhere, but not in New York, not in Charlottesville, not
But it's
anywhere.
legal, there is a Second Amendment, so we do have to deal
Well,
with
you know,
that.
I don't support an interpretation of the Second Amendment which vindicates that, and I'm glad I have the right to say so. I mean, you know, as far as I'm concerned, the U.S. Supreme Court and the Second Amendment are at odds with reality, and I'm glad I have the right to say so.
Okay, next question.
Hi, my name is Ashish Kumar. I teach in the School of Communication and Television and Interactive Media. One of the most interesting broadcast regulation cases that I talk about with my students is that of Everett Parker versus WLBT. And WLBT, for just very briefly, was a station in Jackson, Mississippi that was routinely editing out coverage of civil rights protests in an area that was predominantly black. And Reverend Parker and his, if I'm correct, law students researched the case very thoroughly, and they used a very interesting way to get to the station, which was the 1927/1934 provision that broadcasters must use the airwaves in public interest. And his argument was that this station, being in a black-dominated majority area, was not serving the interest of its populations, and therefore very creatively got the license renewal of WLBT to stop. My point from that is that in view of existing laws that protect speech, and we think of them as hate speech, one has to be creative in responding to them without gutting what we all consider to be a very font of freedom in the new world and so on. And to the point of the guy who rode down the car and mowed down innocent bystanders in Charlottesville, is there a way to look at the funding for these organizations in the same way that we examine the funding of terror organizations throughout the world, and then get to the point of routinely kind of bypassing the issue of free speech, but looking at what harm is being caused to the public by their actions? And that's my question.
To which the answer is, of course, right? I mean, conspiracy to engage in acts of violence is criminal. Funding is criminal. And as I also mentioned briefly at the beginning, broadcast regulation is under a special regime which, although it hasn't in fact been enforced since the Reagan administration, but in terms of political activism, one could, consistently with the Constitution, reinstate a fairness doctrine, and that would all be fine, and those are all fertile grounds for political action.
Okay, but it's not covering Facebook or Twitter, which are unregulated, and you can buy as much influence on those venues as you like. And the CERD, the Convention on the Elimination of Racism, which we are a party to, but we took a reservation to the part that says funding racial, you can't do that I read at the very beginning. Precisely the kind of regulation that you called for. Let's address the financing. We said, no, we're afraid that it will inhibit speech.
Not quite the same. There's a complete difference between funding acts of violence, like driving cars into demonstrations.
Funding acts of violence.
Right? And
Funding
funding communications of, character, of objectionable character.
Olivia?
Hello, my name is Olivier. One question. Where do we draw the line to avoid another Charlottesville, and that both the left and the right would agree? And also, or should we invite moments like Charlottesville to show the world how disgusting those views are and reaffirm our morals?
Well, it seems to me that we're all, the concept that, direct incitement to imminent unlawful violence is illegal and should be, I think, is something that everybody's, and that's true, again, no matter who's inciting the violence against who. The concept that the forces of the police should be there protecting everybody in their right to say how awful the other guys are, I think is something that we agree on. And when done, I think, although, it puts sometimes large financial expenses on towns, on universities, on other venues, but when done, I think winds up doing what it should do, not just as a demonstration of our virtuous First Amendment, but for the reason that was stated at the beginning, and that the Nazis showed when they ultimately canceled their march in Skokie after winning the court victory because nobody was going to turn out. It was going to be very embarrassing, right? The communicative power of protests in accordance with the First Amendment, we believe, in accordance with John Stuart Mill, will eventually carry the day slowly over time in socially desirable directions.
Should hate speech that acts against the other tenets of the First Amendment be blocked or banned, such as speech that says that a religious group should not be allowed in a country, or that they should all die or something like that, or that a black African-American newspaper or media outlet shouldn't be allowed to express their views?
Well, look, the whole purpose of the Constitution, which contain a lot of regressive features that have been changed over time, right, is that you can say so. In other words, if I say the whole problem with the country is that we ought to have an established church, and it should be X, and everybody should be required to pay taxes for that established church, and that would bring morality back to the country. Right? That's totally against the tenets of the Constitution. Right? The Constitution absolutely prohibits that, but I can't be punished for saying the Constitution is totally wrong in that respect, and the underlying ideology of not having an established church is totally wrong, and lots of countries around the world have thrived under an established church, and we should have one too. Right? I'm free to say all of those things.
But you're free to say all of those things, but it's different from saying, kill the Catholics. Those are two, and I didn't bring this out, but in the Danish Cartoons case, it's the difference between hate speech against a religious group and anti-blasphemy laws, which we don't know about in this country, thank God. But these are laws that protect religions in many countries throughout the world. Denmark had such an anti-blasphemy law, and they told those who were protesting against the Danish cartoonists, that's the action that you should bring. So they did, and that was thrown out of the courts. But the idea is there's a difference between protecting religion and prohibiting hate speech against the human beings who believe in that religion. Again, saying send them all back somewhere.
Hi, my name is Lola. I'm a political science, women's studies, and history major. And so I do a lot of work in social justice activism. And one thing that I've learned or realized is that there's not really like enough shame about American history. I mean, like black people were like literally worked to death, beat to death, hung. And we're still allowing people to walk around in Ku Klux Klan outfits, wearing blackface or waving the Confederate flag. And I feel like that kind of like desensitizes our history, and that I think that if there was like a bigger consensus on the fact that the United States had a really bad, excuse my language, shitty history, that there would be like a bigger consensus on not allowing this racist hate speech to continue. And so yeah, I just wanted to hear what you guys had to say.
I completely agree, and I
That's
hope,
perfect.
and I hope,
Why
and I hope,
not?
I hope my friend, I hope my education friends, right, will make it be. No, we'll make it be, right. So those views are much more widely shared among broader segments of the population than they now are. In which case, the legal restraints won't matter, and if not. And if those views are not widely shared, legal constraints aren't going to do any good. And that's the underlying anti-discrimination lesson, whether it's about race or any other ethnic group, the Poles, the Irish, any group, and sexual minorities and any others, right? When the social consensus is that the hatred is wrong to be condemned, that's where we need to be. The legal bits are really not at the center of the ultimate social story.
Yeah, well, our Constitution really did not, I think, speak to education specifically. I mean, there are the first 10th and 14th Amendments that did speak to education and pretty much, gave states the rights to educate in the way in which they saw for the students or the young people in their particular states. So a national curriculum we don't have, but it would be great to have age-appropriate instruction in the ugly history of the United States, that racism is woven into the fabric of this nation. And there's consequences for that we have to pay for, that there's questions of reparations. My students the other day, they had a Lincoln Douglas style debate, and one of the issues was to how are we going to hold accountable these textbooks firms that are intent on whitewashing history and doing things like calling people who were enslaved workers.
And I would answer that, which is saying this is a perfect example of activism at the local level in which the progressive groups have been out-activated by the conservative groups big time. They have been running candidates for the Texas textbook procurement authority for every local school board that controls curriculum. There is nothing that the other guys have done that you guys can't do, and you should.
I was going to say we have time for 2 more questions, then I'm going to let you all sum up. Go ahead.
In regards to Charlottesville, the Nazis that were there, they are being held civically responsible because they're getting fired from their jobs through social media. But if they go and try to sue their employer and then they're protected under the First Amendment, what are the repercussions of that?
That's a very tricky legal area, and it goes more or less like this. As a general matter, on a blank sheet of paper, anybody can fire anybody from a job for any reason they want. They're not the government. Okay. However, that is restricted by law in every place, so that I can't fire you for reasons of race and in a number of, and depending on local law, maybe not for your Vietnam veteran status, maybe for whole bunches of things. At some point, there then comes a question of whether the restriction in itself is a First Amendment violation. That is to say, there are places where I can't fire you for expressing a view that is protected by the First Amendment. At which point, you now get something like the Master Shop case, right? So far, we have managed to draw a pretty convincing line, right, between action, like firing you from your job, right, and belief, like believing that whatever group it is inferior. I expect, therefore, that the plaintiffs are going to win in the Master Shop case because, for one thing, the implications for all other civil rights laws would be enormous if it came out the other way. And I would expect, on the same theory, that if somebody were fired from their job for participating on one side or the other in Charlottesville, that would stand up.
Last comment?
Hi, my name is Susan. I'm the NASA director of the ACLU in the county. So interestingly, when Charlottesville blew up, I was in Cape Cod with my friend from the Netherlands and her daughter, who were just so clear with me and outraged that I would talk about free speech at a time like this. And now, after hearing some of the provisions of these international documents, I've been familiar with some of them, but I do have some questions about them because it seems to me, I heard you say that there is a qualification or disqualification on the word you used was dissemination of ideas to some extent. I think I heard you say that. And then I think I heard somebody say that there is a ban in some places on Mein Kampf, which means there's book banning, and then also images. But let me tell you something about Mein Kampf. Mein Kampf, because I had read it, is how I knew what Donald Trump was. Because I had read Mein Kampf. I saw the tactics years ago. So anyway, so that's part of my question. And as far as Dr. Lightfoot, I think that, and so this was like a perfect storm for me because I fight for social justice issues and racial justice issues and economic justice issues, but also for free speech. So it is a conundrum. We all need to learn more and teach our teachers that they are the foot soldiers of the narrative.
First line of defense. Yeah.
Yes, and I went to Columbia. I have a master's in education. I was not taught any kind of sociology of education. That the teachers are the carriers of the message. They're not being taught that at all. So I think that needs to happen. Anyway.
I would tell you that the founder of the ACLU, Roger Baldwin, was not a lawyer. He said, I hired lawyers. Right? The future of civil liberties does not belong to the lawyers. No question, it belongs to the people.
So that was a perfect plan. She was not a plant. I'm going to end there. This was a really good way to end. Go ahead.
The quote was, you got the phrase, but I muddled the rest of it. This is from CERD, the Convention on the Elimination of All Forms of Racial Discrimination. And it does say, all dissemination of ideas, but listen, based on racial superiority or hatred, incitement to racial discrimination, as well as acts of violence or incitement to such acts. So it's not ideas. You can rant on about speech forever. You just can't rant on about ideas based on that you can't listen to speech from certain groups of people because they don't count. They can't.
Okay. So this is terrific. Thank you. I want to thank Dr. Lightfoot, Professor Stark, for being here. This issue is not going away. away, needless to say. You'll have a lot of opportunity to continue to debate and learn about many of the aspects of this issue. We want to encourage you, by the way, to keep coming to these events. October 18th is an event on immigration that's also sponsored by the Friedman Center, looking at the first year of Trump. So thank you very much for coming.